The Affordable Care Act was back before the U.S. Supreme Court for oral argument on November 10th. The case is California v. Texas. We've been talking about this for several years as it's worked through lower courts, appeals courts, and now back at the U.S. Supreme Court. It's actually the 7th time in 8 years that the Affordable Care Act goes before the Supreme Court. And under threat is the entire existence of Obamacare. The lawsuit challenges the constitutionality of the individual mandate. That's a piece of the Affordable Care Act that says everybody has to have insurance or pay a penalty. Now, the other piece of the conversation is if that falls, does the rest of the Affordable Care Act fall with it? Is it severable? Can you get rid of the individual mandate and leave all the other protections, which we'll talk about in just a minute? Or does it go all at once? The Trump Department of Justice has not supported the Affordable Care Act. They actually filed a brief back in May that said the individual mandate should fall, and with it, the rest of the Affordable Care Act. They actually changed their mind. Originally, they said you could get rid of the individual mandate, but keep the rest. But in May, when they filed their brief, they said get rid of the whole thing. The U.S. Supreme Court has ruled on the Affordable Care Act 2 other times in recent history. The first was 2012, the most notable, when Chief Justice John Roberts wrote the opinion upholding the individual mandate as constitutional. Then again, a couple years later in 2015, both Roberts, joined by Justice Kennedy, were important votes that ruled that tax subsidies to make coverage affordable should be allowed for all states. But the opponents didn't relent, and now we're back before the U.S. Supreme Court. There are about 18 Republican-governed states, led by Texas, that sued in 2018 to strike the law. And then again, like we said, the Trump administration joined that effort. The only parties left defending the Affordable Care Act were called intervenor states, states attorneys general that stepped up and tried to defend the Affordable Care Act by briefs and then now in oral argument. And that charge was led by about 17 states, with California leading the way. The basis of this most recent challenge is the passing of the 2017 GOP Tax Cuts Act. It zeroed out that tax penalty for not having insurance. Opponents argue that if the rule says if you have to have insurance or pay a penalty, and if there's no penalty, then you don't have to have insurance. You can't have the individual mandate survive without the tax. That's their argument. That went before the court on November 10th in oral argument, and some are actually optimistic in the way that the conversation went based on how a couple of the judges were asking questions. Chief Justice Roberts and Justice Brett Kavanaugh asked questions that suggested skepticism that all of the Affordable Care Act must fall if that individual mandate falls. If they were to find the individual mandate not constitutional, should the rest of the Affordable Care Act be tossed as well? Justice Roberts said presumably it wasn't Congress's intent to throw out the whole law. He noted that in 2017 with that Tax Cuts Act, Congress could have thrown out the law at that time when they zeroed out the penalty, and they chose not to. So he doesn't see why the court should be asked to do that now. He said that's not the court's job, is to make that kind of decision. Other justices commented a little bit more on the common sense of the arguments before them. Justice Sonia Sotomayor didn't like the argument for striking down the whole law. She said at some point, common sense seems to make her want to say, huh? And that was her quote during oral argument, saying that this doesn't register that this is what was intended, and it doesn't make sense. There are 3 important considerations that we should talk about with the Affordable Care Act as a whole. The first one is open enrollment. It's the Affordable Care Act's open enrollment season right now. It runs until December 15th. That is foremost on a lot of shoppers' minds, people purchasing insurance for 2021. They had November 1st until December 15th to do so. The lawsuit before the U.S. Supreme Court will not change coverage in 2021. It doesn't change the plans, the prices, the tax credits, the structure, anything. Any decision that comes from this court, from the U.S. Supreme Court, from this oral argument, is not expected until the middle of 2021, June at the earliest. So for shoppers purchasing insurance for 2021, don't let the conversation about this Supreme Court challenge impact your enrollment decisions. You have a very short window to sign up for health coverage, and you need to make sure you shop and purchase a plan before December 15th. Another key consideration is the outcome of the election. A Biden administration supports the Affordable Care Act. Candidate Joe Biden at the time criticized Republican efforts to toss the Affordable Care Act, let alone tossing it during a pandemic. President-elect Biden says he hopes to buttress the Affordable Care Act after taking office January 20th with what could be executive orders, with other mechanisms to try to strengthen the provisions of the Affordable Care Act. Legislatively, a Senate with a Democratic majority could help bolster or protect the Affordable Care Act, rendering the Supreme Court's decision moot or even unnecessary. The last important consideration, COVID. These Supreme Court arguments come at a time when more people are turning to the Affordable Care Act for help during a pandemic than ever before. And it's the Trump administration's own numbers that support that statement. It was earlier this year, it was April and May numbers that were provided by the Centers for Medicare and Medicaid Services that said almost 500,000 turned to the ACA in the spring of this year. Amid the COVID economic downturn. Now that we're in the open enrollment period for the Affordable Care Act, we're seeing even more people flock to the mechanism that can get them private health insurance. Over 135 million people identify as having pre-existing conditions. Now that we have COVID, about 10 million Americans have been impacted by the COVID pandemic thus far in the United States, just adding to the number of people that experience a pre-existing condition. And as you know, the Affordable Care Act created protections for people so they could not be discriminated against by insurance plans if they did have a pre-existing condition. What's at stake? Well, it's estimated that over 22 million Americans have health coverage directly because of the Affordable Care Act, but it reaches just about everyone. The reach of the ACA impacts those with job-based coverage. It impacts people with Medicare. Prescription drug savings is included in the Affordable Care Act. It impacts people with Medicaid, not just Medicaid expansion, but covered services that weren't provided for before through state Medicaid programs. Also at stake, not only eliminating discrimination against people with pre-existing conditions, one of the key elements of the Affordable Care Act, but consider some of the other provisions of the Affordable Care Act that are at stake in front of the Supreme Court. The ACA limited annual and lifetime caps on insurance and eliminated harsh age rating and gender discrimination. It created essential health benefits, mandating coverage for things like maternal coverage. If you have a new baby, it cannot be denied by insurance. Newborn health services and screenings, prescription drug coverage. It created dependent coverage for children up to the age of 26 so they could stay on a parent's health plan and therefore continue their private insurance. It protected affordability with things like premium tax credits, cost sharing reductions, rebates for consumers when insurance company profits outpaced claims, and it added risk stability mechanisms to insurance marketplaces with things like risk corridors. The Affordable Care Act created, like we said, Medicaid expansion. It was implemented by about 39 states, and that includes Washington, D.C., where the federal government helped pay 90% of the cost of the Medicaid program, letting vulnerable populations gain coverage for the first time. So what's next? Well, this lawsuit at the very least creates confusion and uncertainty, weakening the country's public health and economic recovery. The Affordable Care Act, but it's so entwined in our society, it could prove nearly impossible to rip it away from people that have been depending on it for the last 10 plus years. Expect a decision from the U.S. Supreme Court in the middle of 2021, most likely in June. And maybe we'll hear something from the Biden administration before then. In the description below, we give you a bunch of links. The first one, you can listen to that Supreme Court oral argument. We link to that YouTube link in the description below. You can track the docket files. You can read what the parties have been saying in their briefing before the court. You can also read that CMS report that talks about how more people are turning to the ACA during the COVID pandemic than ever before.